Good morning friends, this is my 202nd video. Namaskar, Sat Sri Akal and Adab. This video will cover the latest judgment which came on standard table rent filed by the local Shillong Association in a writ number 343 of 2022 and writ number 344. So there were two people or three people who had filed this writ in the High Court of Shillong, and the decision came on 5th June 2024. So what is the basic pleading which the writ holders or the leasehold people, this writ was basically filed by all those residents who were lessees in Shillong. So they allege is that without a procedure laid down in relevant rules, the STR or the demand for lease money has been done, and consequently the action of the Cantonment Authority is exorbitantly arbitrary. So once again, what are the people doing? They are asking for a natural justice. And what does the defendant say? Defendant very clearly comes to the court and says that as per the CLA rules, the provisions relating the management of properties vested in the Cantonment Board, including power to lease, fixing of and collection of rents under Rule 8 and 10 of the CLA, mandates that STR is required to be prepared in consultation with the district collector. He's right. Now let's see what Rule 8 says of 1937. The MO in consultation with the district collector shall from time to time compile in the form prescribed in Schedule 2 STR for applications to sites for agriculture and non-agriculture purposes in the cantonment, having regard to the situation of the site, the nature of the soil and the rates charged for adjacent agriculture lands or for building sites in the neighborhood. Now what is this? It's a very vicious open statement given in this law, in the rule, that in the vicinity. So vicinity would be the civil municipality there, or is it the rural area like in Kasoli? We don't have a municipality next door, so we have those semi-rural areas, villages. The intention of this rule is that both buildings and agriculture lands in cantonment should be divided up into different survey numbers or groups of survey numbers, and that an appropriate annual rent at so many rupees per acre or biga for agriculture land as so many rupees per 100 square feet or square yard for building sites should be fixed for each survey number or group of survey numbers. So it's again group. The interval at which the STR should be revised must depend on the rapidity with land value fluctuating in a particular cantonment. Maybe in 5 years, could be probably excessive, but it should be understood that the revision will affect only future disposals and will not involve any alteration in existing rents until the period fixed in the leases expires. To all lands in the cantonment which is vested in the crown except for B2 lands which is permanently occupied by provincial governments. Now what are the provincial governments? Let's say that the PWD office, the courts, the RTO offices or the police or the post offices, these are the ref. 3. It will be one of the most important duties of the MO to make themselves thoroughly acquainted with the local value of both agriculture and building lands. They should collect and tabulate information as to prices paid from land in the open market, in private sales and other transactions, and they should avail themselves to the fullest extent of the advice of the local revenue or land acquisition officer, who is considered to be an expert of this knowledge. Now, Rule 10 says, maintenance of journal land register. So, where is the questionability now coming? Why is the defendant mentioning these two rules? MEO shall maintain the GLR prepared under Rule 3 in respect of all lands, other lands in bazaar, the management of which is entrusted to or vested in the board, and shall register all mutations in column 1 thereof and shall enter therein. Every transfer of right and trust in land in the cantonment registered under section 54, 59, 107, 123 of the TPA Act 1882, of which information has been sent to him under subsection 2 of section 287 of the Cantonment Act to the board by the Tahsildar or the sub-registrar. Such transfers necessitate an alteration in the entries in the columns of the register must be done. The learned counsel admits here now, the counsel for the writ holder, that vide letter printed on page volume 2, 423 or 424, Government of India, Ministry of Defence, letter number 18/35 L&C 54, dated 31st 1st 1976, that there is a procedure to calculate STR. What is left? Once you have admitted that there is a procedure, wide this letter of 76, so you've forgotten the 1937 or the 1925 formula of STR. You are admitting that now it is under the 1976. So here itself the case is diminished. So the STR has to be calculated. Instead of taking the help of an admission, of admitting the government of letter, how do you expect the Honorable Court to look into something prior to 1976? So the counsel is pleading the STR under the said interim policy is incomplete and utter violations of CLA rule. Now here he pleads that the 1976 letter is utter violation of the CLA rules 1937. He is even submitting an example which the court has put in the para, where I could not find this formula anywhere in these 1899, 1912, 1925 or 1937 CLA rules, is with clause 1BA subpara 3, which provides that rent will be revised by 100% after expiry of 10 years, which is contrary to CLA rules. 1937 with the revisions of rent is done after expiry of 30 years up to a maximum of 50% enhancement of rent and not after the expiry of 10 years. So I personally feel he is claiming that in the 1976, so there is an order in 1958-62 that the lease money after every 30 years of the leases will be substantially increased like this, 100% or 50%. So this is where I think the pleader of the writ holders is doing something like this. But he is not elaborating it. Maybe he has done it in the plaint which he is filed as a writ. Where is this formula coming from? Whether 50%, whether 100%? Is it written in the CLA rules in 1937? I could not find it. Is it written in the 1925? No. Is it written in your lease deed which is under Schedule 7 and Schedule 8? That is the question now. So now he says the Government of India Council is pleading that there are 127 leases in Shillong Cant, out of which 116 have expired, 11 are left which will be also expiring within a period of some few years. These leases he submit were made during the British period on a maximum possible period of 90 years. And the lease rent money in 1930 and 40 at that prevailing rate was calculated with an enhancement of 50% after every 30 years. the last preceding payment and 50% increase. Let's say you were paying 1, your 50% increase goes to 2. Now let's say when you come back after 30 years again for a renewal, you were paying 2, another 50 adds 1, makes it 3. So this is how he's trying to say. After 30 years, this has been done. Whether now these leases, 127 which he claims, how many of these leases have been renewed? And how many are still in pendency of renewals? That is the question mark. So there are a lot of admissions which have been done here. And once you admit something, you cannot go outside your admissions and your pleadings. So the writ itself, I'm sorry, was not very well drafted with the laws of the cantonments. Now here we'll talk of what is written. Council of the Government of India is pleading that the STR dated 11/1/1973. Now where is he quoting this letter from? Is on page 426 of volume 2. Again J.P. Mittal. Friends, this book J.P. Mittal, I have an order from the Law Ministry that this book is not for the judicial acumen. It is only for internal circulations of the IDS officers. So we need to educate ourselves on all this. So he says in para 3 of the said instructions, whereby the STR was to provide for rates of rent on the basis of 10 square meter for the entire area, even if such the area exceeds 1/4 of an acre. And what will be the value? Whatever will be the STR for residential purpose, it will be 2.5%. Let's say if your STR has been calculated to 100 rupees per square meter divided by 10 would be 2.5% of it. So 100 rupees divided by 10 square meters makes it 10 rupees. So you will be paying 2.5 rupees annually as market value. This is what the formula says. So Government of India Council again pleads that this letter which he talks of, 1976, which the writ pleader is talking, he quotes para 4, 5, 6, provided divisions of zones, bungalow area to be kept separate, civil area to be kept separate, commercial areas to be taken. So he is quoting everything from this book 424. So now the conclusion comes. Now, you have only filed this letter in 1976, presumably knowing that what you are doing. First, it is noted that as per the stipulation, concurrence of the Deputy Commissioner, East Khasi Hills, who was also made a party in this case, was obtained by respondent number 2 on STR for Shillong Cantonment from 2018 to 2020. And the respondent number 2 has revised the STR based on the said inputs. So that means there is some collector rate which flew into the DO's office, and then the MO and the DO there made these STRs and it was subjected to Cantonment Shillong. It could have been subjected to Cantonment Barrackpur either also. But these are all separate policies. For Cantonment Barrackpur, for Cantonment Shillong, the DO, if it is under one circle, will do it separately. Now the Deputy Commissioner has given it, and he has even approved it by signing. Now under the Schedule 2, the STR is calculated. Similarly, 21-23 things happened like this. There is relevance on the document that the DC of the Shillong is signing this. Whether he is a party, not zones, that is immaterial. So as per the STR letter of 1976, the Shillong Cantonment Board had made zones. It is not actually the Cantonment Board who is making the STR. Friends, please understand. It is the DO who makes the STR. And then it goes to the Cantonment Executive Officer. With regards to other contentions of the CLA Rules 21, even CLA Rules 2021 has been brought into this writ. The STR which has been implemented was without the constitutional mandate. This contention is of no consequences in as much as though the CLA rules 2021 have also come into force on 1/12/2021. So this period of 24 and 26 is very relevant, because every 3 years or 5 years, if you notice, every 3 years your house tax is increased. So every 3 years or 5 years, the STR has to be made. In this context, it is also relevant to mention here that the annual leases rent for these properties were fixed in 1930-40, prevailing rates 50% increase, so and so. The court is again rebrushing the pleadings of the defendants. So 127 leases, rent payable, STRs, 2018 it was brought on table from 17 to so, subject to clause B, there cannot be any arbitrary doings. Now since the board is constituted, DC is a part of it, station commander is a part of it, so where is that anything is being done randomly, the court says. The CLA rules were not followed, is same noted but is rejected. So this pleading of not following the CLA rules either 2021 or 1937, the court diminishes it. Inasmuch detailed guidelines from 1976. Now this is very important. So the court starts from 1976, not from 1937, not from 1925, not from 1899. Because why? You have not pleaded all that. You just walk into the court by half knowledge. The court will interpret what you plead. I remember when I was sitting with the ex-Chief Justice of India, way back before his death, he very clearly said, Mr. Das, just give me one simple statement. Have these pleadings, what you are stating, ever been pleaded in any court? I said, no. She said, then why blame us? Blame your pleader in your knowledge. If you don't plead something, something doesn't come to the court, how does the court interpret it? So that's it. So the bigger problem in this writ is, what are we claiming? What are the facts? How can we move forward? Whether we have to go by 1899 or do we have to go till 221 or 1976? What are these facts? So friends, we need to understand. These facts should be known to the residents. Before you file your suits, I have my STR video already on the channel. People could have watched that. If they don't understand, they can definitely call me up. My numbers are floated on the YouTube channel. Residents, please understand, we were first given leases under the Cantonment Code 1899. So that means anything prior to 1899, let's say your bungalow or your 200 square yards of property, this was an old grant or this was a grant. Okay? Because before 1899, there was no classification also. Understand this. So from 1899, for the first time, lease came in. So Cantonment Code gave leases and 1912 gave leases on a similar pattern and rule that there was a clause either 18 or 12 that resumption can be done of these leases. Now when CLA rules came in on the 1910 Rule 25 or 1925 4 Cantonment Act, CLA rules 1925 very clearly speak that if we want to continue these leases, this is what the British officer is saying in a rule, we have to be very liberal. So this liberality has to be shown so that we can garner some rent or some ground rent or some lease money from these bungalow resident and bungalow owners to convert them from old grant to leases. So they did it in 1899, they did it in 1912, and they were willing to do it in 1925 either or 1937 CLA rules. But they said do it very liberally. You will be surprised today, I'll say, read your leases. All leases made in 1925 or onwards in 1937 does not have a resumption clause. Why? So please educate yourself. Don't just run into courts without knowledge. Because you people lose, you actually hamper somebody else to lose. Because see, the department is one. A judgment either from Shillong, either from Secunderabad, either from Amritsar reaches the department in one day. But we residents and bungalow owners are so selfish, we don't want to share our information. We don't want to get things on one table. We don't want this man to know what this man did. That's where we lose. That's where we are hampered, and the system knows this. We are a divided lot. Now we have to quote from here. You'll be shocked that when they were converting these old leases, either old grants or cantonment code leases into CLA rule leases, a major shift for policy of resumption was done. So this is where the CLA rules. Now the thumb rule taken by the department in 1925 was very simple. It is quoted in a rule that if, let's say, an example was set, let's presume we are giving a lease for 30 years. So we presume that a property or a building will be rented for rupees 230 value. So we'll multiply 230 into 30 years. As simple. The value comes out to be how much? 1200 rupees. So now this amount 230 into 12 plus brackets 20 divided by 30 into 1200 will make it 4600 plus a premium amount of 800. So 5400 you pay and your lease is given to you in 1925 or whether in 1937 or whether today after expiry. We can take this pleading, we can take this thumb rule. When was this thumb rule changed for the CLA rules? Is it written somewhere that after expiry no renewal of leases? The clause of resumption is not there. So yet we people are so ignorant, we fall into the laws or we fall into the executive policies of 1976. And this is what this writ has pleaded. So what is the change? Now STR in 1937, the whole system went to the DC. Why? Because in 1924, when the Cantonment Act and the CLU rules were being made, these cantonment magistrate powers were taken away from the cantonment magistrate, that is the CO now. So then they said, okay, now since this duty has been shifted, so we presume let the DC come up and give us the STR. So he will give us for coming leases. Leases made after 1925, leases made after 1937. So the formation of this entire system was arbitrary. How? Now understand this. In 1985, there was an executive order which passed that the DC or the collector, the station commander, the MEO and the cantonment executive officer will be part of the board membrane. And they will decide every 3 years and 5 years the STR. Friends, understand this STR goes for AVR value, which the tax superintendent does for us. When he calculates your annual rateable value and he charges house tax equivalent to 7 to 9% of it. Now you are being levied, leave apart 2 to 3, 10 judgments of Supreme Court saying that house tax and rent are two separate things. Now I'll share it with you. 1880 when house tax was imposed, it was imposed for cantonment funds. When rent came in, the rent definition of the British is rent or land revenue means the same connotation. There are judgments on it, but who pleads all this? Now what the DO did in 1985, apart from the collector rate, now he plays a role. He says, let us get a static rate also. Let's say the STR or the collector rate of my land is 50,000 rupees per square yard or acre. Fine. So that means if I have a property of 2 acres, my land value is approximately 2 lakh rupees. Everything acceptable. My sale value with the building is approximately 1 crore of the bungalow. Small property of 200 or civil area, that can also be worked out. Now if this property is selling for 1 CR, the collector rate says it is for 2 lakhs plus the building value. So the DO here plays and he says, let me get in the static rate. Kasoli bungalow owners, please listen to this when your house tax exorbitantly increased to 2000%. So this static rate value is brought in, and the increase from the collector rate and the static value is influxed in your STR rate. Let's say the jump is 7000%. So the STR rate will jump from collector rate to 7000%. That's the calculation. So this static rate could be higher, could be lower. That is for the DO to decide. And where does he decide? This is a closed door meeting. Neither the elected member of the board is a part of this board meeting, neither any resident is a part of. We are called under section 73 when an house tax is influxed on us. Then we are called for objections within 30 days. If we don't object, we admit to that house tax. And the very funniest part is, most of us bungalow owners or residents go, we sign the register that we have come here to file our objection. We are hardly heard for not even 1 minute, and the CO would report, okay, we'll listen to you, we'll see to it. So your tax was increased 50%. Now he'll say, okay, fine, everybody is rattling, let's do it 15%. So you people will feel, okay, yaar, without going to court, 35 has been reduced. Okay, yaar, 10% is acceptable, 15. Why? Because you people are ignorant. You don't know there is a tax structure which was made in 1908. But we go by the rule. Now they say, no ji, if the bungalow is occupied by you also, no rental income is being derived through it is also, then also the rental value will be calculated. That's your ignorance, na? And there is no remedy to your ignorance. So the value here increases. So my request is, please, Shillong people, you have done something. You need to wake up from all these doings. So please, friends, bring your facts clear. Bring all, because STR is not just STR. We have to understand what is this notion of rent. How rent was defined. It is defined at various places in the army regulations of the cantonments. I think people in Secunderabad or the Madras presidency, I'm categorically saying Mr. Sarana would be listening, or whether he is not, would admit that ground rent was not being paid or is being paid in Secunderabad cantonment. So what is this ground rent written in the Governor General Order of 1855 for Madras presidency? We need to please wake up. If we can do this, I am there, talk to me. Yes, I keep saying one thing, there are no free lunches in this world. And we have to work hard. We have to, get our things on table. We have to assimilate our evidence. If we can't, then we are nowhere. This is how we will do. We got a judgment from Lucknow on leases. We got a judgment from Shillong on STR. So both the issues have been vetted by one set of high courts. Now do we go to Supreme Court? So can we afford all this? So let us fight correctly at the lower level. Friends, luckily we are there today. You are listening to my videos. 2003 when things happened with me, there was nobody to talk to me. I yet remember those people in Ambala, Sandy and Paddy, who are in bungalow. They were so obnoxious. Categorically they told us, Ronnie ji, fight for yourself, forget being bothered about others. Where are they today? 2003 and 8 and now? People, please understand, we are old grants. We were never converted into new grants. But then why are we being converted into leases? That is the question mark. And then why under the lease we being subjected to a rent? Understand this. Good day. Thank you.